Hey everybody, how's it going? Hope you're having a lovely day. Today I'd like to follow up on the legal threat that I got from WeRecoverData because there appears to be a little bit of inconsistency in the things that they're saying, the things that they're doing, and the things that I have done. And I'm going to try and point out what that is in this video. For those of you who didn't watch my last video, it's 36 minutes. I get it, you may not have the time. Hi, I'm Louis Rossman. I run a data recovery company, and for the past 17 years, my website I sought to be open and transparent, not just about how we do business, but we also describe how the business in general works. And I talk about the practices that I like, I talk about the companies that I like, and I also talk about the practices that I'm not a fan of on my website. And one of the practices that I discuss is this practice of having a fake relocation for data recovery, where somebody will have a listing on Google Maps, yet when you show up to the location, there's no technician on site, and the person who works there is not even an employee of the business that was advertised. This is something that breaks Google's guidelines, and it's very annoying. And it was also one of the items that was listed in the legal threat that was sent to me by this company called WeRecoverData. I decided to do a little bit of investigative work to figure out, maybe I really got it wrong after all. Maybe I'm crazy. And I decided to visit their location. And this is what I had.
We don't have that information. We're kind of like a third party. So you would have to contact them and they'd be able to verify if whatever it is that you need that they'd actually be able to accomplish.
Oh, okay. So I see. So there is no technician. I thought there's gonna be like.
Yeah,
thank
sorry.
you. We're gonna come back.
Okay.
Thank you. Bye.
Yeah, there's no technician. They actually confirm it. The other thing that they said in their legal threat is that I talked about their success rate. And yeah, I pointed out that on their website, there's a screenshot where it says, we do not publish the success rate in order to not mislead our customers. Yet the literal title tag of their website says 96% success rate. So they sent me a legal notice. I'm going to point out some of the statements that they've made that are false, and I'm going to be sending them a follow-up letter of my own. So some of my viewers started emailing me saying that WeRecoverData was making this particular statement online. They said, before publishing his video, he did not contact WeRecoverData to verify the facts or request our response. This was said by someone at WeRecoverData. This was posted on their Google Maps profile, and they have posted it numerous times. They didn't just say this once. They said it over and over and over again. He did not contact WeRecoverData to verify the facts or request his response. So let's examine that a little bit, because this is where it shows up on the WeRecoverData page. If you take a look at their cease and desist notice they sent me, it is from the law office of Zachary A. Westenhofer, 30 Wall Street, 8th floor, New York, New York, 10005. And they also sent me a copy of that digitally, which is over here. You could see that this was sent into our ticketing system at our store. Now you can see if I scroll down, it says, "Hi Zachary, the attached letter has just been sent to you via USPS priority mail and is currently on the way to you." And if we click on that, you will see the very same letter that I sent them that I read on the screen. This letter was sent to Zachary A. Westenhofer, the law office of Zachary A. Westenhofer, 30 Wall Street, floor 8, New York, New York, matching the exact same address that was on their form. According to USPS tracking, it was signed for by Z. Westenhofer. My letter says the following: WeRecoverData can identify a specific sentence and show that it is false, in which case I will correct it promptly and in good faith. If WeRecoverData identifies a specific statement it can show is false, Rossman Repair Group will address it. You received my email 16 days before I did my video. You received this letter and signed for it 13 days before I did my video, which makes your statement false. As is pointed out by members of my audience, them claiming you posted your video before contacting them may actually constitute grounds for a countersuit. That's a genuine example of defamation, as said by Dude Guy 2330, given that it's a knowingly false statement meant to characterize you as trying to squeeze out a competitive edge through underhanded means. Next up, what do they demand of me? They said, WeRecoverData has preserved evidence related to your publication, including copies of the webpage, publication dates, source links, screenshots, archive materials, etc. You and Rossman Repair Group are hereby placed on notice that WeRecoverData anticipates litigation concerning the matters addressed in this letter. Accordingly, you are under a legal obligation to preserve all potentially relevant evidence in your possession, custody, or control. This includes, without limitation, all drafts, edits, revision history, source materials, screenshots, archive pages, etc. So the way that I interpret this is they're saying, you better keep a copy of all of this stuff so that you can't change it later. We don't want you destroying any evidence. In my response, I said as follows: your letter asked RRG to preserve records, and Rossman Repair Group will meet its preservation obligations. Tied to the same dispute, Rossman Repair Group asked that WeRecoverData likewise preserve and not delete or alter the records relevant to these claims, including the lease or service agreements for the locations WRD advertises, substantiation for its advertised success rate, terms of service, pricing records, and records concerning the solicitation and management of its online reviews. This request is tied to the dispute your letter describes. It is not a threat to publicize, report, or expose anything, and Rossman Repair Group makes no such threat. My website used to have archived source links to the statements that were made by WeRecoverData, and when you click on those Wayback links, you get this URL has been excluded from the Wayback Machine, even though these links worked just a few months ago. And when I checked their robots.txt, they have disallowed the Internet Archiver from being able to show archive links. Conversely, if you check out my website on the Internet Archive, you'll see that my Internet Archive goes back to before 2012, and I'm pretty sure that I don't even know how you drag it. Here you go. There's a scroll bar. If you drag this over, it goes all the way back to 2010. I'm a very understanding person, but somebody that's a little bit more cynical, more pessimistic than me might be of the opinion that the reason that you were claiming that you did not receive my letter, which not only asks for whatever statements are wrong so that I may correct them, but also asks that you uphold your end of the bargain in evidence preservation for discovery, is so that you could wipe archive.org and claim that you didn't do anything illegal because I didn't ask you to preserve evidence. That's not what's happening here, is it, Zachary? Your client's not trying to remove evidence that would actually show that my website was correct in what it said, would it? There's no way your client would be doing that. So I'm just going to assume that edit to the robots.txt was a stray web developer. It had nothing to do with this case. This is a pattern that I've noticed over and over again, and you tell me in the audience what you think in the comments down below. Every time I've gone over a company, almost 100% of the time on YouTube, that I go over a company that's suing somebody else for defamation, they seem to have this habit of deleting all of their own website's records from archive.org, so you can't reference what they said. So in this case, where DCS was suing a small YouTuber for talking about their warranty, they actually got rid of all the archive.org references on their website that demonstrated that they were lying about their warranty. They said that the warranty had last been updated in 2021, when in reality it was actually updated last in 2022 or 2023, so that somebody who didn't get a paper copy of their warranty wouldn't understand that they had the right to have warranty service performed on their battery if it dropped below 80% rather than below 70%. Dragonfly and Battleborn also did the same thing with their batteries. After Will Prowse started to show that they had serious issues working at spec, they changed the specification in the datasheet, and they also got rid of a lot of those links on archive.org to the point where the only place I could find those datasheets were on third-party provider websites. It's a pattern to me that I'm just going to point out there, that every time somebody is suing somebody else for defamation because they don't like what they said, it seems to follow that they try to remove every piece of evidence of what they said that would actually allow them to be held accountable. If that website is no longer on archive.org, it can be edited so that every single thing that I said you were saying, and then I just sound like a crazy person that's yelling at nothing. That's not what your client is doing, right, Zachary? He's not entering into litigation and then destroying evidence. You wouldn't have a client that does that, would you? You wouldn't be advising your client to do that. I'm sure you wouldn't. And I'm sure your client is not doing that. I would like to read you my letter, and I'm going to be reading it here on YouTube, in addition to sending you a copy via physical mail and email, because this is the only way I can get your client to respond. And it's very important that we settle this, because your client has made several false statements about me that I can prove. Request for correction, clarification, or retraction pursuant to Texas Civil Practical and Remedial Code, Section 73.055, and Evidence Preservation Demand. Dear Mr. Westenhofer, this letter follows your June 19th, 2026 letter on behalf of WeRecoverData.com and Rossman Repair Group, Inc.'s June 26, 2026 response to it. It addresses two discrete matters that have arisen since that exchange, and it does not reopen the merits of the webpage, Is WeRecoverData Safe? The positions Rossman Repair Group, Inc. and I stated on June 26, 2026 stand. Part 1. WeRecoverData's published statement that I did not contact it before the video is false, and I request its correction under Texas Civil Practical Remedial Code, Section 73.055. WeRecoverData is publishing as an owner reply in its own Google business profile listing, WeRecoverData Data Recovery Austin, Inc., the following statement about me observed in July of 2026. Before publishing his video, he did not contact WeRecoverData to verify the facts or request our response. That statement is false, and WeRecoverData's own records establish its falsity. WeRecoverData, through you as its counsel in this matter, opened this correspondence with the June 19, 2026 letter, which you emailed to help@rossmangroup.com on June 23, 2026. I responded by letter dated June 26, 2026, in which I declined WeRecoverData's demands and expressly invited WeRecoverData to identify any specific statement it contended was false so that I could consider it. On June 26, 2026 at 1:46 p.m., I emailed that response to you at zach@westenhoferlaw.com as an attachment titled C&D response. I noted that a copy was on its way to you by USPS priority mail. That copy was delivered to your office in New York, 10005 on June 29, 2026, and was signed for by Z. Westenhofer under USPS priority mail tracking number. Each of these communications was directed to WeRecoverData through you, and each preceded the video, which was published on or about July 12, 2026. The United States Postal Service's proof of delivery for that letter, including the recipient's signature exactly as USPS recorded it, is reproduced below. Whether I contacted WeRecoverData before the video is an objectively verifiable question of historical fact. A statement is actionable in defamation only when it is a statement of verifiable fact rather than opinion. Bentley versus Bunn. And WeRecoverData's statement asserts a verifiable fact that its own files disprove. WeRecoverData's reply tells readers that no contact occurred before that video, that I produced it without ever contacting WeRecoverData or giving it an opportunity to respond, and that my account of the dispute is one-sided and cannot be trusted. That portrayal is false on WeRecoverData's own records, and it injures me in my occupation, the publication of documented consumer protection criticism. A statement that injures a person in his office, profession, or occupation is defamatory per se under Texas law. WeRecoverData published this statement while your files, as its counsel, held both my June 26, 2026 email and the letter signed for on June 29, 2026. WeRecoverData thus asserted that I did not contact it while holding the proof that I did. That bears on fault under any applicable standard, including the federal constitutional actual malice standard, which is satisfied when a publisher in fact entertains serious doubts about the truth of its statement. Saint Amand versus Thompson, 390. I make this request under Texas Civil Practice and Remedial Code Section 73.055. This request tracks the sufficiency of elements of Section 73.055D. It is in writing. It reasonably identifies the person making it, Louis Rossman. It is signed below by me as the individual defamed. It states with the particularity the statement alleged to be false and defamatory, and to the extent known, the time and place of the publication, and it alleges the statement's defamatory meaning. I request that WeRecoverData, 1. Cease publishing the statement on a Google Business Profile listing identified above and anywhere else it appears, and 2. Publish a dated written correction or retraction and confirm in writing that it has done so no later than July 31st, 2026. That deadline is within the statutory window under Texas Civil Practice and Remedial Code Section 730.057. I need to get lunch before I read more of this alphabet soup. A correction, clarification, or retraction is timely if it is made not later than the 30th day after receipt of the request. I reserve all civil remedies available to me if WeRecoverData does not correct the statement. Part 2. The duty to preserve evidence is mutual, and I ask WeRecoverData to confirm it as preserving its native site records. Your June 19, 2026 letter places Rossman Repair Group, Inc. under a duty to preserve all potentially relevant evidence, which you define to include archive pages and revision histories, and it warned that a failure to preserve, and I quote, may constitute a spoliation of evidence. Your words, not mine. In the same letter, WeRecoverData represented that it itself preserved evidence. WeRecoverData has preserved evidence related to your publication, including copies of the webpage, publication dates, source links, screenshots, archive materials, and related records. Rossman Repair Group, Inc. responded in kind. Its June 26, 2026 letter that you received stated that it would meet its preservation obligations and asked, and I quote, WeRecoverData likewise preserve and not delete or alter the records relevant to these claims, including the lease of service agreements for the locations WeRecoverData advertises, the substantiation for its advertised success rate, its terms of service and pricing records, and its records concerning the solicitation and management of its online reviews. 2 facts about the current public configuration of WeRecoverData.com bear on preservation. The Internet Archive's Wayback Machine now returns, and I quote, this URL has been excluded from the Wayback Machine for WeRecoverData.com and serves no snapshots of the domain. The domain's robots.txt currently disallows the Internet Archive's crawler by name, while permitting other name crawlers. Because the site, as it existed on the relevant 2026 dates, cannot presently be retrieved from the Internet Archive, the native records in WeRecoverData's possession or control are the material evidence of the site's prior form. A duty to preserve arises when a party knows or reasonably should know that there is a substantial chance that a claim will be filed and that evidence in its possession or control will be material and relevant. Brookshire Brothers Limited versus Aldridge. WeRecoverData's duty attached no later than its own June 19, 2026 letter, which stated that WeRecoverData anticipated litigation. Blackberry, stop that. Damn cat. I asked that WeRecoverData confirm in writing by July 31st, 2026 that it is preserving, in native form and with metadata intact, the WeRecoverData.com site as it existed on and after the relevant 2026 dates, including its native HTML and source files, its backend server and access logs, its content management system and database records, all historical versions of its robots.txt file, its terms of service and pricing pages, and the review replies at issue in part 1 of this letter. In your written response, please state when the robots.txt directives disallowing Internet Archiver and archive.org bot were added to the WeRecoverData.com robots.txt file, and confirm that WeRecoverData is preserving every record showing the date and manner of each change to that file, including version control history, deployment records, and hosting provider change logs. The date of that change bears in the preservation issue this letter addresses, and Rossman Repair Group will seek it in discovery if this matter proceeds. I reserve all rights, including the right to speak spoliation remedies in an adverse inference instruction under Texas law if material evidence within WeRecoverData's possession or control is altered, deleted, or rendered inaccessible after WeRecoverData's duty to preserve arose. This preservation request is tied to the dispute your letter describes. It is not a threat to publicize, report, or expose anything. Sincerely, Louis Rossman, individually and on behalf of Rossman Repair Group. Govern yourself accordingly. Now I know why you sign your emails with that, Zachary. I feel really powerful after saying that. Everybody in the audience, just try that for a moment. Say it out loud. Think of somebody that has annoyed you, and then just say, govern yourself accordingly. Pretty cool statement. Your client is not trying to wipe the history of the items that would be in dispute in this court case off the internet, is he? That's not what's happening here. I'm going to assume the best of you. I'm also going to assume that you, as an attorney, are not advising your client that he should be doing things like removing his website from archive.org or removing the very history of things that you asked me to preserve for myself, right? You're not applying a different standard to you for evidence preservation for discovery than you're asking to be applied to me. You're not purposely ignoring the letters and making claims that you didn't receive them when you signed for them, right? Govern yourself accordingly. That's it for today. And as always, I hope you learned something.